can one prove emotional abuse in a divorce case? My name is Goldman. I'm the director of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. And today we're going to discuss how do you prove these things in the way of emotional abuse. I mean, the question really bespeaks a problem. If it's your word against his, forget it, okay? It's going to be a very, very tough case because, you may have been living with it for a long time, but the court, just sees two people that are dressed nicely, that seem to be, credible and believable and cordial, and it'd be very hard to say, oh, he did that to me, or she said that, and the person will say, I'm sorry, Your Honor, I don't know what he or she is referring to, but I can assure you I would never do something like that. And then the court has to flip a coin on credibility. It becomes very, very difficult. It gets a little less challenging if the abuse comes in the form of something that may be backed up by a video, by a text, by email, something that shows a little bit more of the non-standard type of behavior that can turn into abuse. And in this day and age where people seem to record everything and just, yell into their cell phones as they send a text out and all that, you'd be surprised, but you're typically able to find some pattern and practice of abuse if it exists. But you got to remember one thing. The court has its own set of definitions about things. The court, for example, defines emergency as meaning something very different than what you and I may regard as an emergency. Something that we may say is an emergency, the court might say, well, what's the big deal about that? Nothing's burning, so leave it be. Same thing with abuse. What you may regard as abuse, what I may consider abuse, the court may not think is abuse, at least not within the meaning of what the court needs to do to get involved. The court will often look at behavior, but isn't quick to label it abuse or non-abuse. If you really think it's abuse, the first question the court's going to ask you, did you call Child Protective Services? A lot of times people don't do it, and the court thinks, well, if you didn't call CPS, it must not be abuse. So you've got to be careful about it. I would say that, it's way better to prove abuse by showing the court external evidence than your own internal word. Your word against his word is going to be tough, but if you can bring other people who witnessed it, if you can bring text messages or email or video verification or something that shows, emotional disorders, anger management issues, these kind of things, it goes a long way towards supporting your case that you're involved in an abusive situation, and that could be relevant when the court determines custody and parenting time. If you have any questions about that, reach out and we'll be glad to help you out.